Welcome to another Explainer. Today, we're diving into a genuinely fascinating workplace legal battle. It's a classic David versus Goliath story, and we're going to decode all the complex legalese to show you exactly how a massive legal defense can just unravel when it collides with its own internal documents. We're looking at a case involving the United States Postal Service and a former employee.
Here's our roadmap for today. We'll be covering 1. A costly legal defense, 2. The missing workplace safeguard, 3. The sham affidavit doctrine, 4. The cat's paw theory, and finally 5. Predicting the court's decision. Let's jump right in.
Section 1. A costly legal defense.
Now, take a look at these numbers. The running total for the government defending this lawsuit is estimated to be somewhere between $280,000 and nearly $700,000. That staggering price tag instantly tells us why they are fighting so desperately to make this case just go away. When the financial stakes are that high, organizations will literally pull out all the stops to prevent a case from ever reaching a jury.
And to stop that financial bleeding, the employer filed an MSJ, or a motion for summary judgment. Think of this as a costly Hail Mary. It's essentially a legal trap designed to kill the case early on. For those of you who aren't lawyers, an MSJ is basically the defendant telling the judge, look, even if we view all the facts in a light most favorable to the plaintiff, we still win legally, so let's just cancel the trial. But here's the catch. For an MSJ to actually work, the defendant's story needs to be absolutely rock solid. And as you'll see, this defense was anything but.
Which brings us to Section 2, the missing workplace safeguard. Okay, this right here brilliantly illustrates the fatal flaw in the employer's argument. They claimed the employee's medical protections just automatically expired. But wait, their own strict written rules required any changes to be thoroughly documented in writing, which they completely failed to do. To try and patch this up, the employer filed a declaration from an official named June Montenegro. She claimed the accommodation had an automatic expiration. The problem? Well, she gave the court a bureaucratic conclusion with absolutely zero backbone to support it. No written rescission, no revised assignment, no physician release, and no order saying the Postal Service could just ignore the employee's medical restrictions. Just her word against their own written policy.
Now, instead of producing the required paperwork, management actually admitted under oath that this vital medical protection document was inexplicably thrown in the trash. You really can't make this up. Manager Williams submitted a declaration stating that if a workers' compensation claim isn't accepted, this crucial document, known as PS Form 2499, is just discarded. This was a massive unforced error for the defense. By stating this on the record, they transformed a standard missing document defense into a highly suspicious missing record problem. They essentially admitted they threw away the exact paperwork that protected the employee.
We really have to remember the human impact here, right? The harm wasn't abstract. That PS Form 2499 was the literal workplace safeguard that should have prevented the plaintiff from being assigned outside his medical restrictions. Once that document inexplicably disappeared, management was free to deny knowledge, demand updated proof, override the restriction, and then characterize the predictable consequences of those over-limit assignments as misconduct. Think about that for a second. The defendant removed the very protection designed to prevent the harm and then blamed the plaintiff for the harm that followed. They manufactured the problem and then punished him for it.
Let's move to Section 3, the sham affidavit doctrine. Things get really dramatic here. Have you ever heard of the sham affidavit doctrine? Think of this legal rule as the court's way of saying you cannot magically reverse your sworn memory 2 years later just because your lawyers realize your original story is losing the case. If a witness says, I know nothing about this, in a deposition, but then later files a document saying, actually, I remember it in vivid detail, the court can throw that new testimony out entirely. It's a mechanism designed specifically to prevent witnesses from creating fake disputes just to avoid a trial.
Take a close look at this, because this literal signature from 2024 locks management into their original story. Back then, they swore under penalty of perjury that they had no idea the employee had any medical restrictions at all. During the initial equal employment opportunity investigation, the safest defense for the employer was simple: we didn't know. Both Manager Williams and Supervisor Cisneros signed affidavits swearing absolute zero knowledge of any medical conditions, restrictions, or requests for accommodation.
But watch what happens next. Facing defeat in 2026, those exact same managers suddenly submitted new declarations filled with highly specific memories of discussing those exact restrictions, light duty and job searches. It's a wholesale reversal. Why the sudden pivot? Well, text messages and timekeeping data surfaced, proving they absolutely did know about the restrictions. So, completely trapped by the paper trail, they changed their story from "we didn't know" to "we knew, but the documentation was outdated." The sham affidavit doctrine argues that these 2026 declarations shouldn't be viewed as just an update. They should be thrown out as a manufactured bad faith attempt to avoid a trial.
Moving on to Section 4, the cat's paw theory.
This is such a fascinating legal concept. Cat's paw liability is a theory where an employer is held liable if a biased, lower-level supervisor acts as a puppet master, manipulating unaware upper management into firing a targeted employee. The term actually comes from an old fable, where a monkey convinces a cat to pull roasting chestnuts from a fire. The cat burns its paws, and the monkey gets the treats. In employment law, the biased supervisor is the monkey, and the higher-ups who blindly sign the termination papers, they're the cat's paw. So even if the final decision-makers claim they weren't biased, the company is still responsible if they blindly relied on a discriminatory supervisor's tainted reports to pull the trigger.
And here is how that unbroken chain of causation mapped out in this specific case. Step 1. The biased supervisor, Cisneros, mandates medical violations and makes age and FMLA threats. Step 2. Cisneros feeds this manipulated attendance record to upper management. Step 3. Management blindly relies on this tainted record to fire the employee without any independent investigation. Supervisor Cisneros didn't just mandate the shifts that violated the employee's medical limits, he also issued the prior suspensions. Plus, there's evidence he made direct threats regarding the employee's age and protected leave. Upper management relied entirely on that poison file to justify the firing, creating a textbook cat's paw scenario.
Which brings us to our final part, Section 5, predicting the court's decision.
So how does this all wrap up? The plaintiff isn't just relying on one lucky argument here. They have built 3 completely independent lethal roadblocks against the employer's defense. First, the sham affidavit doctrine destroys management's credibility. Second, the cat's paw theory proves the termination was manipulated by bias. And third, the employer's own internal policy violations and discarded documents invalidate their core excuses. Any single one of these grounds would probably be enough to defeat the MSJ and force a trial. But taken all together, it means the employer's defense has virtually nowhere to hide. They've essentially supplied the plaintiff with all the evidence needed to defeat their own motion.
As we wrap up this explainer, I want to leave you with this question. What happens to the foundations of workplace fairness when an employer blatantly ignores their own written rules, discards vital protections, and changes their sworn story to hide the truth? This David versus Goliath battle serves as a stark warning to any organization that tries to litigate their way out of their own paper trail. Because when the documents don't match the narrative, the truth almost always finds a way to surface. Thanks for joining me as we deconstructed this legal puzzle. See you next time.